Hey Localogy team, it's time for another quick take. You may or may not have seen earlier this month that a ruling came from the Supreme Court in the UK in a case called Lloyds versus Google. The case was about whether or not a class action, which is a group of people moving together effectively as one plaintiff against one defendant, or sometimes more than one, in order to get claims settled that otherwise would be impossible to do, either because they're too small or the amount of controversy is not enough. It's a powerful tool for holding to account and sometimes suing large-scale actors. Now, they don't come much larger than Google. And luckily for Google, in this case, the Supreme Court of the UK concluded that class actions can't proceed in cases around data where there's no evidence of actual harm or damage to an individual. Now, what this means is, in order to be able to bring a class action claim, each individual person who's a part of the class would need to be able to show that they suffered some kind of financial harm, some kind of psychological harm, very similar to cases in products liability where if you're a member of a class and you're suing, let's say, a car manufacturer, you would need to be able to show that not only did you own one of the cars that was in question, but also that it harmed you in some way or that you lost value. This is an important case because it kind of diverges from the rule in the US, where the US Supreme Court has given much more leeway for claims about data breaches and harms without direct showing of injury to individuals in certain instances. And it's a surprise because usually the US Supreme Court is less favorable to class action claims than the UK Supreme Court is. So it was a big win for Google, but they shouldn't break out the champagne just yet because the case was decided under the predecessor law to the GDPR. So that's the Data Protection Directive, which was enacted in 1998. GDPR is, as we all know, quite different and has different regard for the rights of individual data subjects. So it's entirely possible that a case alleging individual harm in a data breach or data usage case like Lloyd was might make it through under the GDPR or its analog in the UK, the Data Protection Act 2018. We'll just have to see, but at least for now, you're beginning to see an interesting divide between the way the courts in the US and the courts in the UK think about cases involving data. And that's information that you should always incorporate into the way that you think about your own data. I'll talk to you next time on another Quick Take.